Good morning, everyone. Good morning, Instagram, YouTube, Facebook. I'm just going to let you guys tune in. Come on in, come on in. Let's chat. Let's talk about submitting a VAWA application and what that entails and what happens when you submit one. Good morning, everyone on Instagram. If this is your first time tuning in, definitely comment. Let me know it's your first time. Let me also know where you're tuning in from. Same for you guys on YouTube and Facebook. Let me know where you're tuning in from. If you don't know me, my name is Aisha Chidole. I'm an immigration lawyer. I help clients get green cards, U.S. citizenship, through humanitarian-based immigration or family-based immigration. You can reach me 407-995-6567. You can also send a WhatsApp to 404-333-8751. Also, if you're on Instagram, it's going to be in my profile. If you're on YouTube or Facebook, it's just scrolling through the ticker so you can save the numbers there. Tuning in from Los Angeles, good morning. Campbell Marv from Florida, first time. Welcome. Michelle from Jamaica. What's a guan? Oja says it's her first time from Maryland. Welcome. Phoebe, an Ethiopian by way of Atlanta. Welcome. Montego Bay, Jamaica, Golden Leaf. Welcome. Um, first time heading to Buffalo, New York, taking my son to college. Congrats. Is your son going to SUNY Buffalo? I actually went to school upstate New York. I went to college at Binghamton, which is like a sister school to SUNY Buffalo. And me and my sorority sisters used to go to Buffalo, to party sorority life. So somebody is asking, it's 407-995-6567. Okay, let me try and type it in here and just 995 and pin it so you can see the number. All right, so pin, how do I pin this again? Just give me a second, guys. Let me figure out how to pin it. Okay, so I've pinned it on there. Wow, Haiti is also from upstate New York. So many upstate New Yorkers today. Welcome, welcome. So today I want to talk about what happens basically when you submit a VAWA application. What the cycle is. So first of all, I know there's some newcomers here, or maybe this is your first time hearing about VAWA. VAWA is basically, it stands for Violence Against Women Act. I'm going to talk about it in the immigration capacity. So Violence Against Women Act is basically an act that was passed by President Biden, actually, when he was a senator several years ago, which basically allows immigrants, I'm talking about the immigration component of VAWA, that allows immigrants without status who entered the country. So either you enter the country with a visa and your visa has expired, or you enter the country without inspection, or you enter the country in maybe with a crewman visa or a COD visa, to adjust their status and get a green card if one of the following applies to them. Okay. Oh wait, someone says, as an IO, I watch many other immigration attorneys and I want to say you're one of the best. Thank you so much, Jay. I really, really appreciate that. Thank you so much. So basically, these are the types of circumstances in which you can fall under this. So number one, if you're married to a U.S. citizen or a green card holder, and your U.S. citizen spouse is extremely cruel to you and abusive to you, you could be eligible to submit a VAWA application and therefore getting your 10-year green card that way. You can also be eligible if you are a child under 21 and you have a parent or a U.S. citizen parent or step-parent or a green card holder, your parent or step-parent who is abusive to you and extremely cruel to you. And then the third category is if you are the parent of a U.S. citizen child who's over the age of 21. So the key here is that your child must be a U.S. citizen. So with the other categories, the abuser could be a legal permanent resident or U.S. citizen. But when you as a parent are alleging that your child is abusive, that child must be a U.S. citizen, and they must be over the age of 21. So, when you put in this application, which is essentially what I'm talking about, and then I'm going to jump into questions. When you put in this application, one of the first thing that happens is typically, you get your receipts, your receipt notices. USCIS typically considers these applications very confidential. So they generally want a safe address to send that to. If you're working with an attorney or working with our firm, we always use our address as the safe address, just because for a lot of clients, if they're living with their abuser or they don't have access to their mails because their abuser doesn't give them doesn't let them see it, or whatever the case may be, it's risky for them to send these mails there. So they use our office. But for some other people, you can always get another family member to be a safe address, a family member that you trust, or you can always go get like a USPS mailbox. I think, I don't know how much they are, but they have like a really inexpensive monthly rate where you can get a mailbox and have your mail sent there, just if you want to make sure that it's confidential, because for a lot of people, this is a situation of life and death. Okay. So and then the next thing is you want to, and once you get your receipts, typically USCIS is going to look at your application and they're going to review it to make sure that you meet, it's like a preliminary requirement. Sometimes some people refer to it as a pre-approval, but a pre-approval, look at it like a mortgage, right? You can be pre-approved for a mortgage, but it doesn't mean that you'll be approved for a mortgage, right? There's still some other things that you're going to consider before they do that final approval. So preliminary is just kind of like, okay, on the surface, you meet all the requirements, and the typical things they're looking at to make a prima facie determination is, one, they're looking to see that you have that the relationship that you're saying you have, either as a spouse, as a parent, or as a child, that relationship does exist, right? So if you're, let's say, in a marriage situation and you're filing on the basis of marriage, key things that they're looking for is that they're looking to make sure that you properly terminated any previous marriage. So if, let's say, you're in you divorced outside the US and you're not sure if your marriage was terminated correctly, it is a good idea to seek counsel from a lawyer back in that home country to make sure that you terminated your marriage correctly, and look at the US, reciprocity guidelines of what a correct, divorce looks like for your country. Right. So that's what they're looking for. And then, of course, with the others, you want to show that that's your parent or step parent, or you want to show that that's your child. With step parents, they're looking at what age did your parents marry, and things of that nature. Okay. With step parents, basically, you want to have been married before 18. Before you turn 18, the parents have been married before you turn 18. And then the next thing they're looking for in a case of marriage is that not only that you're legally married, but that you have a good faith marriage. What does good faith mean? A genuine marriage, that you entered into your marriage genuinely. You didn't ask for this. This was not like, to circumvent the immigration system, but you entered into the marriage genuinely, and this is what happened to you. So the third thing they're looking for is they're looking for a proof of abuse, and I know people have a lot of questions about this. And, a lot of times, people are like, well, there was no physical abuse, or, I don't have any evidence that he punched me or that she slaps me, or whatever the case may be. But there are many forms of abuse, which I can talk about in another live, that will still be considered extremely cruel, and abusive for the purposes of this application. So abuse is not only physical, and as many victims, or I should say survivors, will tell you, there's some abuse that's worse than physical, even sometimes. And then once you establish that, they're also going to be looking at are you a person of good moral character? So generally, they're looking back 3 years, unless there's reason to look further back. They're looking 3 years. So let's say, you came into this country in 2022, and you filed for VAWA in 2023. So they're looking as far back as 2022. So, you want evidence of good moral character even in your home country. So, if you came from like Bahamas, you want to get the police clearance, or proof, back there to show that you have good moral character. And then, of course, getting a police clearance or FBI clearance here, showing that you have good moral character. So clearance is basically saying you don't have any arrests that are considered crime of moral turpitude. And then, if let's say you have like some petty arrest, petty offense, they're looking to see, what other evidence of good character do you have? Do you have affidavits from your church? Do you have affidavits from a community, a volunteer, your place of work, etc. So basically, if you meet those preliminary guidelines, you will get a prima facie determination letter. And with a prima facie determination letter, depending on the state you're in, you will get certain benefits. For instance, some states will give cash assistance or housing assistance, but have a prerequisite that you cannot be living with your abuser in order for you to get that. An example of a state that does that is New York. I mean, there are 50 states, so I don't know what the rules are in every single state. But just using that as an example. And then there's some states that with, a prima facie determination letter, you can get a driver's license while you're waiting on your work permit. One of such states are like Georgia, or Florida, where you can get a driver's license, you can drive around and you're not like, held hostage by however, you need to get around. For some, you can also get assistance to go to school. And prima facie determination letters, what typically happens is that the first one you get will be a year. And then after that, it will be renewed every 6 months. I know sometimes I get comments where people panic and say, so like someone, for instance, says, I received my prima facie. This is a question actually right now, where she says, I received my prima facie and it expires March 2023, what follows next? So in that case, you don't have to reach out to USCIS saying, my prima facie has expired. Can I get a new one? They will automatically send this to you. A lot of times you will probably get it after the expiration date, but it's nothing to panic about because you already have your prima facie that is established. They will send it to you. It's just that sometimes it's late. And they will basically keep renewing that until they make a decision on your case. Most VAWA cases take 2 years to 2.5 years for them to make a decision on your VAWA case, and then you move over to adjustment of status, which is where you didn't get the green card. And then after the prima facie determination letter, you're basically in a period of review and timeline and waiting for your turn. So from a timeline perspective, if you submitted an adjustment of status application and a work permit and a travel permit, you will get that next. If you didn't submit a work permit application with an adjustment of status, you won't get a work permit until they make a decision on your VAWA case and you requested one. So most work permits, when you submit for VAWA, you're going to see somewhere between like 4 to 9 months. You can fall in any window there, but I would say about 70 to 80% of people fall within that window. And then once you get your 2-year work permit, your 2-year travel permit, you hold on to that and use that to work and travel until they make a decision on your case. If they still have not made a decision on your case before 6 months to expiration, then you want to make sure that you're filing for renewal of your work permit, just because these take a long time to get. And then a few things happen in this waiting period. So you can either get a request for additional evidence, or you could get a notice of intent to deny, or you could get an approval. With a request for additional evidence, they're basically saying we don't have enough to make a decision on your case. Give us X, Y, and Z, or explain X, Y, and Z. With a notice of intent to deny, which with a notice of intent to deny, you don't have a lot of time to reply to that, so you have to be very quick with your response. In that case, they have all the evidence they need, and based on all the evidence they have, you still don't qualify, or they don't believe you qualify. So you need to rebut that. You need to prove that you do qualify. And then the last one is, of course, an approval. If you get an approval, you get what we call deferred action, meaning you're deferred from any kind of deportation, and then usually they will transfer your file over to field, your local field office for them to then either schedule you for a green card interview or bypass you from an interview and maybe request your medical and issue your green card. When you're issued a green card, you get a 10-year green card, regardless of whether or not regardless of how long you've been married, but, most VAWA cases, by the time, you get your green card, it's been, a few years. And then when you get that 10-year green card, you'll be eligible for citizenship at the 3-year mark. So you have to wait 3 years and then you can apply for citizenship. So that is kind of the life cycle of a VAWA application all the way through getting citizenship through VAWA. I see a lot of questions, so let me try and take some questions real quick. Africana says, best team on the planet. Thank you so much. Augustus from Atlanta, thank you for tuning in. And Africana from New York. Marsha says this is her first time watching. Good morning from Florida. Thank you so much. How long does it take to process a green card after the VAWA is processed? So like after your VAWA is approved, I would say on average, we see somewhere around like that 6-ish months, sometimes earlier, but 6-ish months is typically the average we see. All right, let's see what we've got on Instagram. Someone said pin your number. Okay, I typed it in there and I lost it, but I think somebody else typed it, so I'm gonna pin their pin it right here. Thank you, Felix, for typing my number. So I'm pinning it in there. Okay, mine just popped up. Just 1 second. Pin comments. So you guys should be able to see my number. Okay, Dee said her son is going to Buffalo State University. Good for him. Congratulations. What about students completing 5 years in the university and wanting a green card? For students, if you don't have any path through family, the best way would be through your employment. You want to try and, get an employer to sponsor you, like, for an H-1B. And, through that process, you can get your green card. For a lot of people, if you major in a STEM major, which is science, technology, engineering, and math major, you increase your chances of this happening just because you have 3 chances of doing occupational training and potentially getting someone to sponsor you. Okay. Please, my friend's prima facie expired last year and she hasn't gotten a renewal. Also, she applied for a work permit together and I still haven't gotten it. Please, what do you do? With that, Sophia, we have to first of all see if you, with the work permit, we would first of all need to know, did you apply with the right category and did you have an adjustment of status application attached to your application? Because a lot of times people will either apply with the wrong category or there's no adjustment of status application attached. So we need to know that. With the prima facie, as I'm sure you heard me earlier, even though she may not have gotten a copy, her prima facie is still established. What she can do, since it's been about a year, is she can just reach out. It's possible they sent it and either she didn't get it or, it was returned back. So you can reach out with VAWA. You have to send a letter and ask for it at that point, saying, you never received it. If you have an attorney, your attorney should be able to help you with that as well. Okay. Let's see what else we have. Thank you, D Lady, for buying a badge. I filed for my son, who's 26 years old, over 5 years, not yet approved. For how long does it take? So over 5 years, I'm going to just do a math and assume that when you filed for your child was 21 years old. The problem is that once your child is over the age of 21, meaning 21 and up, they come out of being your child from a status perspective, and they go into a son or a daughter in a family preference category. So typically when it's a child, it's any child under 21, and they have immediate status. There's always visas available for them. Once they become 21 and over, they become a son and a daughter, and then they enter family preference categories, and these preferences can change depending on whether the child is married or not. I'm going to make an assumption that your 26-year-old is not married, and so they're probably in the F1 category, which is a U.S. citizen applying for any child that's over the age of 21. With that, it's based on the visa bulletin. I don't know the numbers right now for September as far as years, but it's somewhere between 5 to 6 years that you're looking at, or 5 to 7, typically in that category. So he's still within that time, and it's possible that he'll may get his I-130, and then you have to look at the visa bulletin to determine when to do his National Visa Center application. Heber says, "Good morning. I like your videos. Very informative, not long and boring." Thank you. Getting a mom and daughter who are from Jamaica documents to come to America. I'm not sure if that's a question. Epistle Latin, thank you for tuning in for the first time. How long after applying for a work permit is Social Security being issued out? I think that's a question you're asking. Again, most people for the 9 months, your Social Security usually will come maybe like a few days or a few weeks after the work permit comes. Official Shima says, "You're so good." Oh, thank you so much. Inash says, "Can you please make more content on T visas?" Okay, I will try to make more content on T visas. Or maybe I'll talk about that also maybe on my next live. Noma says, "Please save this live." I will save it. Emmanuel says, "Is it advisable to travel with a parole from your VAWA?" The answer to this really depends. It really depends on, basically where you are in your case. So let me give you some different examples on how I personally advise my own clients. If we're starting a brand new application, you entered into this country with inspection or without inspection, but this is literally your first entrance. You've never applied for anything with immigration before, never had a removal case, not a removal. If you get a travel permit and a work permit, you can go. You just always want to know that when you come back, sometimes you could be called into secondary questioning. If you submitted a marriage-based application, and then something happened, and then now you want to submit a VAWA application, or you submit a VAWA application and want to join that I-485 from your marriage-based case, which your VAWA application, which we call abeyance, generally, the only category of people that I would say are okay to travel are those who maybe USCIS will send an RFE to either your attorney of record or to you saying, "Okay, give me the proof of the VAWA receipt." Once you submit the proof of the VAWA receipt, then we know for a fact that they're holding your case in abeyance. The only unfortunate thing is that a lot of times, even though you request an abeyance, you're not really going to hear anything from USCIS. You just assume, because they've now made a decision, that they're holding the case in abeyance. In those cases, I'm very iffy about people traveling, because if they then say, "Well, we're denying the case," and you just so happen to be outside, we're denying the abeyance, and you just so happen to be outside, then you're stuck. And then the last category is if you had an interview before you came to us to submit a VAWA, and we're trying to get an abeyance, I absolutely don't recommend it. Again, unless you get an RFE saying that, because they could just deny your case after an interview without giving you an NYD or an RFE, and they could simply just never have received the abeyance, or it was never transferred there. So in that case, I wouldn't. So those are different categories. What can you do if immigration loses your file? Loses your file? Well, I mean, I would need to understand a little bit more. What do you mean they lost your file? Like, did you get receipted for the file? Because if they gave you a receipt, then your stuff is in the system. You just need to do a FOIA to get the information. But if you're saying that you never got a receipt, then you should send a new application if it's lost then, because if not, you're just wasting time. Jihan says, "Very informative. Thank you." Favorite Carrie says, "Good morning to the best immigration life." Favorite Carrie, how are you doing? I haven't heard from you in so long. Good morning. Okay. Let's see. I have a 2-year green card and it's expired. I filed again and I was given a 48 months, but I was expecting a 10-year green card. Is that the process? This is a very, very good question because so many people are confused by the extension that they get. So typically, every single person who submits, okay, let me go back. If you've been married for under 2 years at the time they approve your green card application. As long as it's under 2 years, you will always get a 2-year conditional green card. Okay. When you get the 2-year conditional green card, at the 2-year mark, you need to be filing a removal of condition application to get your 10-year green card. By default, so there's no extra special treatment to anyone, there's no skill to this. By default, when you submit that application for removal of condition, you will get a green card extension. What the confusion is that over the last 2 years, the extension time has changed from 18 months. And then I remember in September of 2021, it changed to 24 months. And then sometime last year, it changed to 48 months. So as this change happens, depending on when you start in the process, they will keep updating you and sending you a letter with the new changes. And the reason why it changed is because it used to take them that short of a time to make a decision. But then with COVID and all the backlogs, it started taking longer for them to review removal of condition cases. So by default, if you are applying now, you should get a 48 month. You shouldn't get the 18 month or you shouldn't get the 24 month. As of the time that they decided that it was going to be 48 months, that's what you should be getting. The 48 months, you counted from the date of expiration on your green card, not from the date you received it. From the date of expiration of your green card, you count 4 years to that. This is not a 10-year green card. You are still a conditional green card holder. This is just basically saying, because we're reviewing your case, we don't want you to be out of status, and we're going to give you this document showing that we're extending your conditional green card while we make a decision of the case. Now, depending on how solid your case is, or how solid your marriage is, or how solid your case and abuse is, if you hit the 3-year mark from the date in which you received your original conditional green card, you may be eligible to file for naturalization, which is to apply for citizenship. All of that is determined, at least let me speak for myself and my firm, on a case-by-case basis, and understanding the person's case, marriage, what application they submitted, and all of that stuff. It's never a good idea to submit a naturalization application blindly. I always tell everybody a naturalization application is the most straightforward and most simple of all the applications. However, it is the most difficult application to get approved. So, because being a citizen is the prize. So you want to make sure that strategically you're eligible and you can get that approved. If not, it's like a waste of your time. All right, guys, I gotta jump off, but I was glad chatting with you guys. I'll try and do some more visa content like somebody requested. If you want to schedule a call consultation, call 407-995-6567. You can also WhatsApp us 404-333-8751. All right, guys, have a wonderful Tuesday, and I will talk to you guys later. Bye.